lecture on Chapter 1, which is the legal and constitutional foundations of business. This chapter and the second chapter are very important to the course because they provide the foundation for all of the other chapters that we will cover. And so you will see the application of this chapter and Chapter 2 throughout the rest of the course. It's important to understand the basic topics in this chapter. Keep in mind, just as a general proposition, that the law itself is a set of general rules. And the job of the courts and judges are to take those general rules and apply them to a specific set of facts that is found in the case before them. And a judge and a court must also always supply a reason for their decision and why they applied a certain law to a certain set of facts in that manner. So keep that in mind as we go. The first topic in Chapter 1 is sources of law in America. Of course, the first subject is constitutional law. The first source is constitutional law. Obviously, that is a general document that distributes the balance of power amongst the branches of government, and it also provides a framework for all of the laws of both the federal government and all state governments. Any law that conflicts with the Constitution is unconstitutional and therefore invalid. A lot of this first chapter may be somewhat of a review for you of your high school civics, so you ought to be familiar with a good bit of this chapter's material. The second source of law that you ought to know about is statutory law. A statute is a law that is passed by Congress or by a state legislature or by local governments. And the ones passed by local governments are sometimes called ordinances. But any law that is passed by a legislative body is known as a statute. For example, a federal statute is the Civil Rights Act of 1964, which makes it unlawful for employers of a certain size to discriminate on the basis of gender, race, age, national origin, religion, so on and so forth. That's an example of a federal statute. There are some areas of the law where there's been developed sort of a common set of rules that all the states have adopted. For example, the Uniform Commercial Code has been adopted by all 50 states. And so that deals with the sale of goods. And so that's going to be, it's going to be uniform across those states because what we've got is we've developed a uniform set of laws that will apply in that situation. Uniform codes are pretty rare. The Interstate Compact on the Placement of Children, which governs the adoption of children from one state to another, that is also a uniform law. Everybody's adopted that. But just know that in some circumstances, state laws might be identical across states. In most cases, they're not going to be. Another source of law is administrative law. And this comes from the administrative, I would say, branch of government. That would not be entirely true because our administrative agencies are not formal branches of government. They're sometimes referred to as unofficially the fourth branch. But what agencies do at both the federal and the state level is that they have the power to take a statute and then make rules that apply to how that statute is going to be followed, enforced, detailed. And those rules that administrative agencies make, those are also enforceable as laws. So, for example, the Civil Rights Act of 1964 that I mentioned earlier makes it illegal to, let's take the Americans with Disabilities Act. The Americans with Disabilities Act makes it illegal to discriminate on the basis of a disability. Well, the act doesn't define what a disability is. That's been left to the courts and in some instances to the administrative agencies that would carry out that law, such as the Department of Labor, the Occupational Safety and Health Administration. Those are examples of administrative agencies that would make rules that would give these laws, these general laws, more detail. If we passed a tax law, if Congress passed a tax law, then the IRS would be an administrative agency that would then make the rules that would further implement that law. if Congress passed an environmental law, then the Environmental Protection Agency would then be responsible for coming up with the rules that would implement that law. Another thing to remember about administrative agencies is that they also can have their own courts. They're called administrative law hearings. And so it is possible also to be taken to court, so to speak, in an administrative agency as well. So that is a very important source of law for businesses in particular, because a business is subject to all kinds of different kind of regulation, and it's important to know that it's not just laws passed by your legislatures on the state level or Congress on the federal level, but also the rulemaking agencies that exist, again, at the federal level and also at the state level. Another source of law, and this is another big one, is case law and the common law doctrine. So this is based on English law, which we inherited and we still have today. And so what case law and the common law doctrine are is that when courts make decisions about how a particular law applies to a case, then that decision becomes binding on future courts and future people who are in the court system who have a case that involves a similar set of facts and the same law. And so that way, individuals in society have some reasonable expectation of that the law will be applied in a uniform way if they know that in the past courts have applied this law in this way to this situation. And that way we have some sort of uniformity to it. Now, of course, every case is different. The facts of every case are going to sometimes be off by just a hair, and that hair may make all the difference in the world to the outcome. But as a general rule, our courts are bound to follow the precedent, which is past decisions of courts involving the same law and the same set of facts. That is the name for that is stare decisis, and that's a Latin term that means loosely the law will stand or the law will speak. And so that just means, again, these courts are going to follow prior decisions. Now, that does not mean that every court is bound to follow precedent blindly. And it doesn't mean that a court can't ever overturn precedent or go against precedent. That does happen. Some of the reasons for that are that a law that has been interpreted a certain way for a number of years may not be reflective of society's views on those laws. For example, or technology may increase to the point, or may have advanced to the point where the application of a law is no longer practical in today's world. So a couple of examples of that. One is a case that I've assigned you to read in your separate assignments, and that is the Supreme Court case of Brown versus Board of Education. You all should be loosely familiar with this case. It is one of the most important landmark Supreme Court decisions in history, and it was the Supreme Court case that overturned precedent that had been set before by the Supreme Court back in the 1800s that said that as long as white students and minority students were provided separate but equal opportunities, that was constitutional. Well, Brown versus Board of Education came along in the 50s, and it challenged the separate but equal doctrine as it related to schooling, public schooling. And the court had the precedent from prior years that said separate but equal is the law of the land. And at that point, long overdue, the Supreme Court said in the 50s, no, that can't be the law of the land anymore. We're not going to follow that precedent. We're going to overturn it, and we're going to find that separate but equal is unconstitutional. So that's an example of a court not following precedent. Another example is that it used to be that states could not tax internet sales for reasons that will bore you and I won't get into. But as that has become so prolific, now the Supreme Court did have a case in 2018. I've got another assignment for you to read on those set of cases. I think it's the Quill case and the Wayfair case. But what those cases did was that they overturned some Supreme Court law that said that states could not get into the taxation of internet commerce, and they now allow states to do that. So that is another example. Classifications of law. The important things to know in this topic are that just some different ways we classify the law and talk about the law. It's important to sort of know those distinctions. The first one is substantive versus procedural law. Substantive law involves, it creates rights, duties, and obligations, whereas procedural law includes the rules for enforcing those rights. So, for example, we have a law that prohibits murder. That would be a substantive law because it creates the obligation not to kill other people for no reason. And the procedural law that governs how charges must be brought, how people who are accused of murder should be notified, how fast their trials have to come, how their rules for how their trials would go. Those are all procedural rules, and that's a pretty easy distinction to see between substantive and procedural. Another classification is that, this may be obvious, but we have state law. That is obviously laws passed by a state legislature, and also from the common law, decisions that are made by courts of that state. And then we have federal law, which is law that has been either passed by Congress or decisions, common law case decisions by United States federal courts. And we'll get into the difference between state and federal court in Chapter 2. So that is another distinction. Another one that I want you to know about is the difference between civil law and criminal law. So criminal law is exactly what it sounds like. Are the laws that govern what conduct is acceptable and not acceptable, and the conduct that is not acceptable, how it will be punished by society. So that's between the state, in our case the state of Georgia, and an individual who's accused of committing a crime. That's criminal law. Everything that is not criminal law is civil law. So civil law governs relationships between individuals or between individuals and the state. Divorce is civil law. Contracts are civil law. Employment law is civil law. Almost everything that we deal with is going to be civil law in this course. We will do a little bit of study and attention on criminal law as it relates to business, but pretty much we'll be focusing on civil law. The remainder of the chapter is a little bit, again, a review of civics, the constitutional powers of government, the separation of powers, you know about that. Some important clauses in the Constitution that affect business that are important for you to know are, one is the Commerce Clause, and that says that because we have this separation of federal and state authority, and the Constitution delegates certain authority to the federal government, and then it says that anything that's not delegated specifically to the federal government falls to the states to regulate themselves. But one of the specific things that it delegates to the federal government is the ability to regulate interstate commerce. Excuse me. And what that means, obviously, is commerce between the states. That has been interpreted by the courts so broadly that pretty much Congress can regulate anything that has to do with businesses that would engage in any activity or economic activity that would cross state lines or could possibly cross state lines. It's difficult in this day and age to even find an area where Congress would not have the authority to regulate commerce because of the way our society has evolved and is connected outside of state lines. So the Commerce Clause, important thing to know about that is it allows Congress the ability to regulate interstate commerce, which is in turn pretty much everything that has to do with economics and business. The flip side of that is that because Congress delegated that authority to the federal government, state governments then cannot regulate interstate business in any way. That is often referred to as the negative commerce clause or the dormant commerce clause. And so it's read two ways. It gives the federal government this authority, and it also tells the states, you have no authority in this area. The supremacy clause is pretty basic. You'll remember that from civics. That just means that any law that conflicts with the Constitution is invalid, that the Constitution is the supreme law and it will hold over any state laws that conflict with it. The Bill of Rights is important for you to know. That'll come up again on a test, if not in our quiz for this week, maybe on the final. But I do think it is incumbent upon every citizen to know what the Bill of Rights is. That's, of course, the first 10 amendments to the Constitution, and it would be a good idea to know what each amendment covers. I'm going to put a reference page up for you on the Week 1 module that lists the Bill of Rights and which rights each of those amendments covers. Most of the rights and liberties that are in the Bill of Rights are directed at the federal government, but then Congress went and the people went and passed the 14th Amendment. And what the 14th Amendment did was it took the first 10 amendments to the Constitution and said not only do these apply to the federal government, but they apply to the states as well. So in that way, the Bill of Rights applies equally to federal government and state government. The First Amendment, you'll be familiar with the freedom of speech that is protected and guaranteed by the First Amendment. In the business context, it's important to know that the First Amendment protection of freedom of speech does extend to corporate speech. I know it's funny to think about a corporate being a person or being able to speak, but in the eyes of the law, corporate is a sort of fictional person. And so their speech is protected as well. And then it applies to advertising as a form of commercial speech. And as with most of our rights, they're not absolute. So it's important to know that the constitutional right to free speech, as it applies in the business context, does have limits. In other words, we can't have false advertising. We can't have advertising that is obscene. We can't have advertising or corporate speech that would incite a riot. And that makes sense to us as a way to preserve order in society. And that's kind of the same in the same way that individual speech is not absolutely protected either. It's illegal to yell fire in a crowded theater. We don't allow people to make terroristic threats. That's a crime. We don't allow people to defame another. So those are just some limits on that. Freedom of religion is another right that is protected by the First Amendment. In the business context, that would apply to any restrictions that we would place on employment or on employment decisions that we might make that would affect or that would result in the discrimination of anyone's right to the freedom of religion. Another constitutional protection in the Bill of Rights is due process, and that's found in both the 5th and the 14th Amendments, and that literally reads that no person shall be deprived of life, liberty, or property without the due process of law. And what that means is that from a procedural standpoint, procedural due process means that no law could apply to deprive someone of a fair right to be heard, the fair right to know what charges you have or how the law is being alleged to have been broken or violated. And then substantive due process requires the law passed to not violate a person's individual rights in a way that is not compelling or doesn't have a state or federal compelling interest. So due process is basically the general notion of fairness, that laws have to be fair to us and that they don't unfairly infringe on our rights, and then they have to be applied fairly. That would be procedural due process. Equal protection means that, again, no person shall be denied the equal protection of the laws, and that ensures that citizens who are similarly situated are not treated differently by the law. any law that is passed that does do that has to meet a really strict test in order to be found to be okay, valid, lawful, however you want to say it. That's kind of the highlights of the first chapter. I do realize that this is a little bit different for us to do it this way. We don't get to have the give and take of question and answer, and we don't get to give examples and keep kind of going down the road of that. And so, there's not much we can do about it in this format. So my hope is that this kind of abbreviated lecture will be helpful to you. If anybody has any suggestions on ways that would make it more helpful to you or things that you would like to see me do differently, I'm all ears. Always glad to try to improve upon the delivery of the content for the course. All right, so that is all for chapter 1.